if I have understood correctly, that it passes through the people of the house. That is why, Millard, the direction was that lay before the assembly. It has been laid before the assembly, had a discussion. The leader of the opposition also accepts it. But I am not on whether it is in terms of the High Court's order or not. Accepts, and Millard refrains from making other submissions and says it has been properly laid. Now, once it is properly laid, then what is the situation? Yes. Millard, please have a look to my one judgment, Millard. I don't think that we need.
86.
No, what is the step after that, Mr. Dotto?
But thereafter, Millard, we have gazetted it where, for example,
Last paragraph.
your lordship may take, Millard, page number 86. Take as an example, Millard. Page number 86.
Yes.
This is 10th of June. Yes. Now, please take note, page number 87. What is the power exercised? Now, therefore, in consideration of the recommendation of the Commission and in the public interest and in pursuance of the provisions of Clause C of Section 2 and subsection 1 of Section 9 and subsection 1 of Section 11 of the said Act, means it's in the 93 Act, and in continuation of notification dated, etc., the Governor is pleased hereby to subcategorize so and so, so and so, so and so.
66 to 64 হয়ে গেছে। 64 plus is 66.
So this is done under which act?
Yes. Now please take note 93 Act. But after it passes through the legislation or the legislature, then, Millard, I have to exercise my power, Millard, under the relevant statutory provision. Please address 93 Act. Just
No, is that not reflected in this order?
yes, it's there, Millard. The penultimate paragraph, Millard, the last part of the recital at page 87, for example. Or, Millard, may I read it, Millard, from the top, Millard?
Please do.
Yes. Please take note, page number 86. Number, etc. Whereas the backward classes have been defined in clause A of section 2 of the Commission Act 93 for the so and so to mean such backward class of citizens other than the scheduled caste, scheduled tribe as may be specified by the state government in the list. Whereas the list have been defined under clause 2, etc. Then whereas the state commission was set up under section 3 for identification. Then, and whereas in terms of section 9 of the Act, the Commission considers inclusion, over inclusion, and under inclusion of any other backward class and tenders such advice to the state government as it deems appropriate, and such advice of the Commission being ordinarily binding upon the state government. And whereas on recommendation of the Commission and in public interest, the Government of West Bengal published notification subcategorizing so and so, which will mean etc. etc. And whereas the Commission has decided to conduct a benchmark survey through the Bureau of Applied Economics and Statistics and Cultural Research Institute covering so and so classes to determine their degree of backwardness, and whereas pursuant to the receipt of the report of the survey of so and so, the Commission has, based on detailed surveys and comprehensive consideration of all relevant materials and data, formed a reasoned opinion and recommended to the state for subcategorization of 64 classes. Now, therefore, in consideration of the recommendation of the Commission and in public interest and in pursuance of sections 2C, 9(1) and 11(1) of the said Act, that is 93 Act, so and so, as clause category A and category B. Now, Millard, please take note of the statute. I'll come back to a decision of the.
It was done. The legislative process has been
Right.
We are satisfied with that.
Very well.
The notifications are issued under the 93 Act.
Yes. Please, now, Millard, I'll demonstrate from both the acts, 93 as well as the 2012 Act, which survives after your, the truncated 2012 Act.
So notifications were issued before it was laid before the House.
No.
27th May.
Millard,
It was laid before the House in June 25.
yes, these are drafts. Yes. But these are drafts, Millard, which was finally, Millard, as your lordships know, Millard, unless it is gazetted, it doesn't take effect. I don't think I need to dilate on that.
Yes, that is okay. But
Yes.
this is not a, page 86 is not a gazetted notification.
Page 86.
86
Yes.
which are showing. Yeah.
Yes,
It's a gazetted notification.
yes.
Gazetted on
27, yes, 27th
27th
May is gazetted on 10th of June. Therefore, it takes effect on 10th of June. Yes, yes. Just below the state emblem.
Well, it will take it to the- once
Now,
it-
Milord, your Lordship may kindly take, Milord, the 1993 Act.
93.
Here. Okay. I see. And Milord, the last document in the convenience compilation is 11 June, Milord, when all other departments were informed about it.
But Mr. Dotto, this is not a notification under the 12 Act.
93 Act.
90. So we said in our judgment 12 Act, you recast the schedule. You would be at liberty to do so. Kindly
Milord,
come to clause H of our direction.
yes, yes. Milord,
We
there are
say-
two things. One is,
Correct us if I am
yes,
wrong.
yes,
that
ma'am.
this schedule inclusion
Yes,
will
Milord.
be under the 2012 Act by a legislative process.
Right, ma'am.
What you have shown us all are in respect of the 93 Act.
Right.
So no class has yet been incorporated on the basis of this under the 2012 Schedule 1. In the absence thereof, Mr. Dotto, how it can be proceeded?
Milord, may I, Milord, place both the acts, Milord? I'll definitely, Milord, make things clear. Milord, kindly have a look to Milord, the 93 Act first.
You have given us a copy? No.
আচ্ছা,
Yes,
নোটটা দিয়েছো না?
Okay, there.
Milord, we have prepared a short note, Milord, which I have handed up just before handing up the
Yes,
compilation.
yes.
yes. This one.
Yes, yes.
That
Yes.
is good, okay.
But I skip over, Milord, para 1, para 2. Now please take para 3.
Yes, please.
Since the power of the state executive was being taken away through an interpretation of the 2012 Act, the Honorable Court evolved a mechanism for classification of OBC with reference to Section 11 of the 93 Act. In this regard, Direction J is quoted. Therefore, every case of inclusion in the OBC list would refer to the provisions of Section 11 of the 93 Act with obvious modifications, thereby by implication. In this regard, a very limited power was granted to the state government to submit a report to the state legislature based on the commission's finding for the inclusion of class in the OBC list. No other power was conferred on the state government. However, legislature cannot legislate on its own. Therefore, the judgment dated so and so has a specific direction by interpreting Section 11 of the Act, 93 Act, such that the inclusion or exclusion of OBC would take place by laying a report before the legislature with the recommendation of the commission and no other means as was provided. Under such circumstances, the only manner in which the state legislature can make a decision for inclusion exclusion would be for it to deal with such report in terms of the rules of procedure of the state assembly. Rule 319 of the rules of procedure provides for proposal on such matters and discussion thereof. Rule 319 is quoted. A motion that the policy or situation or statement or any other matter to be taken into consideration shall not be put to the vote of the House Speaker and the vote of the House shall be taken on such motion. Here, your lordships have found the leader of the opposition was satisfied. Therefore, my lord, the question of no further.
Yeah, whether leader of opposition or anybody, nobody has objected
No,
to
no,
the,
yes, yes.
has raised any
Yes.
motion.
Any other member could have done so. Thus, no voting is to be conducted on such action, laying of report, unless a member moves a substantive motion in appropriate terms to be approved by the Speaker. In this case, no such motion was moved, and therefore it would be deemed that with the conclusion of the discussion and no objection being made to such report, the same stood approved in so and so. Then, Milord, we have relied upon a judgment. I don't think, Milord, that is very required, but still I'll just read it. Once a report is forwarded to the legislature, the matter exclusively enters the domain of the legislative function, see so and so, and unless any contrary decision is adopted by the legislature, the same necessarily is to be treated as an approval. Once the matter is placed before the legislative assembly, it falls within the arena of the legislators who eventually are the representatives of the people. কোনটা দিয়ে দিচ্ছি তো? না,
দিয়ে দাও।
if my lords require me, I can place that judgment. I don't think that, or just
It's not necessary.
no,
That's
no.
all right.
Well,
It's a legislative passed in the assembly.
well, I will not.
Thereafter, what is the step?
Yes. It is only after the approval of the assembly of the report prepared on the basis of the commission's finding was the approval of the assembly given effect to by the state through publication of the notification, which are statutory orders in the official gazette. This is so because the West Bengal Legislative Assembly by itself cannot make any publication under any provision of law. The same necessarily has to be done by the state government. Then, Miller, the presumption of constitutionality is para 12, then para 13 according to us. Therefore, para 361 of the judgment has been complied with in letter and spirit. It must be clarified at this juncture that this honorable court had reserved the process of inclusion of OBC through list under the 93 Act as opposed to Schedule 1 of the 2012 Act, since Section 16 of the 2012 has been struck down. This court has done so consciously. Yes. In para 361G, I'll elaborate this para 14 for your lordship's consideration. This honorable court has done so consciously in para 361G of the judgment, keeping in mind that placing of a report before the legislature will be the legislative function for this purpose. Therefore, the entire process of inclusion has been carried out by the state exclusively in exercise of its legislative function through the act of laying the report before the WBLA. In this regard, 361B is so and so. Then, Millard, para 16, Millard, is the answer to my lord's subsequent query that what is to be done.
14, Mr. Dotto, we are not fully satisfied with.
Millard,
14, para 14, argument in para 14.
well, I'll elaborate.
That
Elaborate.
is
Yes,
why you chose the 93 Act instead of
I'll elaborate.
25
Definitely.
Act.
I owe an obligation. I owe an obligation to Millard satisfy
Please.
your lordship on that. Then Millard, para 361B, Millard, we have quoted in para 15. Then it is not the case of inclusion through any executive orders, divorce any statute, but by exercising statutory power on the legislative side, and thus statutory orders in terms of 93 Act, 2012 Act as interpreted and read down by the 24 judgment. In light of above, no prima facie case for passing of interim order is made up. In any event, the Supreme Court, that is Millard, my submission. Millard, since Millard, your lordships are satisfied on the legislative aspect, but I don't go into the those provisions of the Constitution which says that legislative functions
No, not
business should
necessary.
not come before
Not
the court.
necessary.
Not necessary. Now, Millard, please take why I have exercised powers under the 93 Act and not under 2012 Act. হ্যাঁ, দুটো দিয়ে জজ সাহেবদের আগে 93টা দে।
93 দিয়ে দিচ্ছি।
Please take me on 93 Act first. না,
Yes.
क्या? Look, Section 9, Millard, your lordships have already considered that this is the commission's power, Millard, for inclusion, over-inclusion, etc., etc. Then Section 10, I skip over. The next chapter, I skip over. No, sorry. Please give me a moment, Millard. Yes, please take, Millard. I'm so sorry, Millard. Please take Section 2, subsection C,
Yes, lists.
lists. Lists mean list prepared by the government of West Bengal from time to time for the purposes of making provision for the reservation of appointments or posts in favor of backward classes of citizens which, in the opinion of that government, are not adequately represented in the services under the government of West Bengal and any local or other authority within the territory of West Bengal or under the control of so and so. Then, Millard, the commission's functions start. Then, please, Millard, your lordships have gone through it a number of times. Please take section 9 once more. Millard, 93 Act contemplates list, whereas 2012 Act contemplates schedule.
Give us the 2012 Act copy.
আচ্ছা আচ্ছা
একটু সুবিধা হবে বারবার
No, আমার দাগ মারা আছে। Please take, my lord, section 2F of 2012 first. But this has been read down by the court.
Yes.
List means list prepared by the government of West Bengal from time to time for the purpose of making provision for the reservation of appointment or post in favor of backward classes of citizens which in the opinion of the government are not adequately represented in the services under the government of West Bengal or any local or other authority within the territory of the state of West Bengal or under the control of the government of West Bengal. This, Millard, your lordships were pleased to read down as the state government of West Bengal means the state in its legislative
capacity.
field or legislative function. This is what, Millard, your lordships have read it down. Therefore, a list is prepared by the government in the exercise of its legislative functions. This is, Millard, what we understood, subject to your lordships' correction. Then, Millard, I don't trouble your lordships with the other. No, পাঁচটা দেখাতে হবে। Yes. 5, section 5, not there. Yes,
বিটা আছে
5A is not there. Yes, I stand corrected. Yes.
it's not there
Five?
why is it?
A gone. The proviso to A survives, B survives.
Right.
Then your lordships may kindly take, Millard, directly to 16,
16.
1-6.
Yes,
This has been struck down by the court.
that's right.
The state government may, by order published in the official gazette, add to, amend, or alter any schedule.
Right.
This has gone.
Deleted,
The-
deleted.
Therefore, Millard, we do not have any power today under section 16 to amend, alter, add any schedule. Therefore, we have to fall back, subject to your lordship's correction once again, on 93 Act. Now, please come back to 93.
No. 1 minute, 1 minute. Mr. Dotto, we have struck down the power of the state executive. We've always said state means state legislature. The legislative process has been completed appropriately. Good, in whichever way, that we will hear them prima facie. The declaration, therefore, had to be a decision of the legislators, of in whichever form, under the definition of 2F and bringing in amendment under the 2012 Act, including a schedule under the 2012 Act, not the 93 Act.
Millard, may I say this, Millard?
Those dictation sections is struck down since it empowers the state executive.
That's right. It should have been under the 2012 Act.
Millard, could I assist your lordship on
Please.
this? Millard, the purpose of the 2012 Act is to provide for reservation in service. Today we are at a stage, or Millard, what is pending or before your lordship for consideration is, my lord, classifying certain classes as OBC or subclassifying them. Therefore, my lord, of the two acts, 93 and 12, please first kindly, if I may, having placed 2012 Act, please, if I may go back to 93 Act, please have a look to 93 Act. Nine one. But list, my lord, I have placed, my lord, definition of list.